Welcome back to Breaking History, the Supreme Court Historical Society's show where we highlight modern scholarship about the Supreme Court's endlessly interesting past. I'm Ross Davies, and today I am joined, again, by Helen Knowles-Gardner. Helen is managing editor of the Society's Journal of Supreme Court History and also research director at the Institute for Free Speech. We are here to talk with Helen today about her latest article in the Journal of Supreme Court History. The title of her article is Without a Little Help from Your Friends, the Supreme Court's Rejection of the American Jewish Congress Amicus Brief in NAACP versus Alabama ex rel. Patterson, 1958. Yes, it is an article about the court's rejection of an amicus brief. There must be an interesting story behind that. And, in fact, as Helen explains in her article, there is more than one fascinating and important story to be told about the Patterson case. So, in the 20 minutes or so we have together today, we are going to explore those interconnected stories, or at least some of them. We will begin with the big picture of the substantive law here, the historical and doctrinal significance of the NAACP versus Alabama ex rel. Patterson case, and its place in the Supreme Court's freedom of association civil rights jurisprudence as it developed in the 1950s and 1960s. After that, we will turn to the strange business of a procedural matter in the case, how the Supreme Court's own rules, combined with a close vote by the justices, prevented the American Jewish Congress and the many other civil rights organizations with which the AJC was working on its brief were prevented from speaking directly to the court in the usual way, via an amicus brief, in the Patterson case. By the way, back in the 1950s and still today, the American Jewish Congress was and still is commonly referred to by its initials as simply the AJC, and that is how we will be referring to it today. So, whether your deepest interest is in substantive law or in procedural law, you should stay tuned for a fascinating set of stories that cover both. So, Helen, please tell us about the Patterson case and freedom of association.
Thank you, Ross. It's a delight to be back on Breaking History to talk more about this incredibly important litigation. So the Patterson case really started in the wake of Brown versus the Board of Education, when states were trying to figure out how they could delay the inevitability in the South of desegregation. And the brand new, as of January 1955, the brand new Attorney General of Alabama, John Patterson, looked around for various different ways to delay that inevitability and settled on a tactic of basically putting the NAACP out of business in Alabama. And he succeeded in doing so for over 8 years. So what he did was to successfully obtain an injunction on June 1st, 1956, saying that the NAACP, as a foreign corporation, a corporation incorporated outside of Alabama, that entity was running afoul of the foreign corporation laws in Alabama. And it was required by this injunction, the NAACP was required to basically cease all business in Alabama and to basically get all its staff and all of its offices closed and all of its staff out of Alabama, basically overnight. Otherwise, they would be, they would be held in contempt of the injunction. And so the litigation starts to unfold, June, July, and then early July. And I like to look upon this as a very strategic mistake on the part of the Alabama Attorney General. He basically upped the legal ante by saying to the NAACP, you have to provide us with lots of information. You have to disclose lots of information to the state. And the key one of the key things that the state requested was a list of the members of the NAACP, every single member in Alabama. They wanted the names and addresses of all of those members. Now, it doesn't take any stretch of the imagination to understand why the NAACP didn't want to disclose this information. There are plenty of stories, not enough time to tell them here, but trust me, there are plenty of stories preceding this litigation of significant harassment of Blacks in Alabama simply because people knew that they were members of the NAACP. So if tens of thousands of names and addresses were to be disclosed to the state, like I say, you don't need much imagination to understand what would have happened. But by upping the legal ante, John Patterson also brought the Constitution into question. And that's why this ends up being a Supreme Court case. And although it took 4 Supreme Court rulings, all unanimous, I might say, in favor of the NAACP, in 1958, 1959, 1960, and 1964, the court rules on all 4 occasions, and the second, third, and fourth rulings basically reinforce what the court says in June 1958, the first time it hears this case, which is the Patterson case, that the First Amendment's guarantee of freedom of speech, freedom of assembly, basically associational freedom, protects the NAACP from having to disclose this private information. And that ends up being a landmark freedom of association decision in Alabama, in NAACP versus Alabama, ex rel. Patterson.
My goodness, that sounds like quite a gauntlet that the NAACP had to run over several years just to be able to safely associate together, the members.
Yes.
Rather a scary business.
Very, very scary, yes.
Mm. But the NAACP was not alone in its fight for civil rights in this context. And this is where your current paper breaks some additional new ground, in addition to some of the work you do about the course of the litigation as well. And that's this AJC, the American Jewish Congress Amicus brief, and all that went along with it. And so could we perhaps start with sort of a quick look at the evolution of the court's rules in this area, and then maybe a closer look at the rule as it stood in the late 50s that informs this problem for the AJC in the Patterson case? And maybe after that, we could then get into the weeds of exactly how the justices did what they did with that brief.
Sure. Absolutely. So this litigation was a procedural minefield. I mentioned earlier that the NAACP was successfully ousted from Alabama for 8 years. That's basically because Alabama tied up this litigation in procedural knots, many of them trivial, many of them clearly just intended to stop the wheels of justice from turning. You know, I always think of this quote from Robert Carter, who was the NAACP general counsel, and he spearheaded the NAACP's fight in this litigation. He said, and I quote, "Our most formidable and possibly insurmountable hurdle in this litigation is one of procedure, not substance, but procedure." What my article does is to tell a story of one of those particular procedural hurdles, but not necessarily a procedural hurdle only of Alabama's making. Instead, when the court decides not to accept the American Jewish Congress amicus brief in this case, the decision was largely to do with the Supreme Court's rules regarding the decision and the acceptance of amicus briefs. So my article goes into very, very extensive detail of the history of Supreme Court rules. And I'm going to try and narrow that down just to a very short summary. So up until 2 years ago, if an entity wanted to file an amicus brief in the case, basically they needed, according to the court's rules, they needed the consent of both parties in the case, unless you were the US Solicitor General, in which case you didn't need to seek that consent. But for everybody else, you had to seek the consent of the parties, both parties, I might add. Or if one of those parties withheld their consent, then you could go to the court and say, will you accept the brief even though one of the parties doesn't want us to file this brief? In the grand scheme of the court's history, a party's denial of a request to submit or amicus brief, or then the court saying, no, you can't submit an amicus brief, that really doesn't happen very often. It's not something that has really dominated the filing of amicus briefs in the court's history. Hence the fact that a couple of years ago, the court just got rid of that consent requirement because all of the briefs were being accepted, and that requirement really had outlived its usefulness. When the AJC decided, and I'll talk a little bit about this later, but when the AJC decided to submit an amicus brief, they were bound by Supreme Court rules that were not exactly clear. There was a lot of unfortunately unclear language in these rules, and I don't know how many times I read these rules, the relevant rules from 1954, trying to wrap my head around them. But I know that however many times it was, I never came to a clear conclusion about what the language of the 1954 rule really meant. So back to the AJC. So the AJC, round about World War II, they created a Commission on Law and Social Action. And that entity, the CLSA, has long considered amicus briefs as a key part of their toolkit with regards to supporting cases that end up at the Supreme Court. To give you an idea of how extensive that has been over the years, the AJC has filed amicus briefs in 111 cases between October 1947 and October 2009. Going back to the Patterson litigation, so not only do we have an entity in the AJC that's heavily involved in filing amicus briefs, we also have an entity which has a rich history of involvement with the NAACP. And so with regards to the NAACP versus Alabama litigation, soon after the June 1st, 1956 injunction is imposed upon the NAACP, the AJC they get wind of this, they start researching this because the threat to the NAACP's existence wasn't confined to Alabama. Various different states in the South were adopting exactly the same tactic. And so the AJC put some of its researchers on to examining this threat. And in May of 1957, the AJC puts out this pamphlet, a 52-page pamphlet, appropriately entitled Assault Upon Freedom of Association. Early in the spring of 1957, right around exactly the same time that this pamphlet comes out, the court grants cert in the Patterson case, and the AJC completely appropriately and as expected gets to work on basically putting material from this into an amicus brief in the case. Again, unexpectedly, again, expectedly and predictably, Attorney General Patterson says, no, you are not filing this amicus brief in this case. And his reasons for it are laughable. We'll just resign those to history. So enter the Supreme Court's rules. One of the parties has said, no, you're not going to submit this amicus brief. So then the AJC has to submit a motion to the court asking the justices for permission to file this amicus brief, despite Attorney General Patterson saying, no way. At the time, the rules governing this were the rules as they existed in 1954. And as I mentioned earlier, these rules are not exactly clear. They are very murky. What do you do with punctuation? Do you take the comma out? Does it change the language? And so on and so forth. Ultimately, in part because of the lack of clarity of those rules, the AJC's motion to file this amicus brief was denied by the justices by a 5-4 vote, in large part because there was an element of the unclear language had to do with the timing of the submitting of amicus briefs. And because the AJC kind of dragged its heels with the filing of this brief, that kind of opened the door for the justices to say, sorry, you submitted this brief too late. However, there's an interesting however to this story. When I started to research this, I printed out the reply brief that the NAACP filed in the case. And I thought, that looks familiar. That looks very familiar. And I put the AJC's rejected amicus brief next to that reply brief. And there was a reason why the reply brief looked very familiar. Large chunks, and I mean large chunks of the reply brief were lifted straight out of the AJC's amicus brief. Only after the AJC really pressured the NAACP to file an amicus brief in the first place. To file a reply brief in the first place. Robert Carter was very reluctant to do that, particularly if it was going to contain verbatim sections from an amicus brief that the justices had rejected. He did not want to incur the wrath of justices by submitting a brief that contained material that they'd already rejected in a different form. Therein lies really the story of the AJC's brief in this case.
So it sounds like the substantive content of that brief did find its way entirely lawfully onto the desks of the 9 justices, notwithstanding this unfortunate detour into a dead end down the amicus path.
Yes, yes, it was not a research path I was expecting to go down until I printed out the reply brief and thought, hold on, I've seen this material somewhere else, and I wasn't imagining things. Yes, you could put the 2 documents next to each other and they say a lot of the same thing.
So, just an aside, moral of the story for practitioners and academics, read all the documents.
Absolutely.
Always read all the documents. I salute you, Professor Knowles-Gardner. That is a great story of scholarship as well as of litigation and civil rights law. Is there anything we really ought to know, that we ought to take home about the aftermath of Patterson and its place in this series of cases, substantively as a matter of civil rights law or procedurally as a matter of amicus practice?
I'm not sure that, because the amicus rules have changed now, I'm not sure that ends up being part of the equation. But I can say that substantively, the legacy of Patterson lives on because we live in a climate where political violence is intensifying and where disclosure of private information is so it's just as important now, I would argue, as it was back in the 1950s. And the principles of the Patterson ruling by the justices in 1958 apply just as much today as they did to the civil rights movement back then.
Thank you very much, Helen, and thank you very much to everyone out there for joining us for this edition of Breaking History. We will be back soon with another new and interesting look at the past.